Good afternoon. This is Cindy Tomei, Vice President with the Illinois Manufacturers Association. It is a pleasure to welcome all of you to our call today. It is not overselling the idea that this has been quite the week. So we appreciate you taking your time to get some of your emergency leave and FMLA questions answered. This call is being recorded and will be available at the IMA's COVID-19 resource page by the end of the day, and you can see that address on the screen. We held a call on Monday afternoon where we touched on the subject of the Families First legislation, but since then we have received literally hundreds of questions regarding clarification and implementation on this act and how it's impacting your companies and your employees. We will try to answer as many questions as possible, but many that we received are very intricate in detail, and it might not be feasible to address them here. We have forwarded the questions we've received so far to the presenters, and they have been able to incorporate the general themes of the most asked questions into their presentations. Any questions during the call can be sent to IMA at ima-net.org. That address is on your screen. If we don't get to it here, please visit our resource page at ima-net.org/COVID-19. We do have a Q&A section on there, and many of the questions have to deal with this particular issue. On the screen that you're looking at now, you will see my email address as well. If you are not an IMA member and are looking for accurate and timely information about COVID-19 and all things related to your business, please contact me and we'll make sure that that gets rectified. We are sending daily newsletters and hosting webinars specifically tied to this issue, the demand that it's requiring of your companies, and how it's playing out in the real world. So at this time, I'd like to introduce our speakers. Norma Zeitler from Barnes & Thornburg serves as outside labor and employment and litigation counsel to nonprofit healthcare, hospitality, and manufacturing clients. Norma represents employers in the defense of employment discrimination, retaliatory discharge, breach of contract, workplace torts, and restrictive covenant cases in federal and state courts across the country and before administrative agencies. Our other presenter is David Ritter, also of Barnes & Thornburg. He represents management nationwide in virtually all areas of labor and employment law. David defends employers faced with state or federal claims under a wide range of employment laws, including discrimination, harassment, retaliation, restrictive covenants, breach of contract, and employment torts. We are thrilled to have them here today to answer as many questions as possible regarding the Families First Care Act and the implementation of FMLA. Their presentation will cover a lot of the questions that you've already asked us. After the presentation is over, we hope to field some of the questions that you are sending to our IMA email box. David and Norma, I'm turning it over to you.
Thanks, Cindy. Obviously, this is David, not Norma. Just know that Norma and I do pretty much the same thing every single day. And for the last 10 days or so, the only work we've really been focusing on is anything related to employment and COVID-19. Norma and I have been talking nonstop during this time period, and we both come broadcasting to you from various rooms in our house. Just to give you an idea, our law firm has about 600 plus lawyers. We do all sorts of work for businesses. We have 16 offices nationwide, and all of these lawyers are now working from various places. I am broadcasting from the bedroom of my 27-year-old, and I'm using his room, and that's where we're all doing. Norma, where are you broadcasting from?
I am broadcasting from what used to be my au pair's room, but now that my kids are old enough that I don't need an au pair, it's the perfect sanctuary for me to broadcast from because nobody comes upstairs.
So what we're going to do today is I did the program for the IMA on Monday. I brought in Norma as reinforcements. Things have been changing daily and sometimes by the hour. In fact, we sent a new presentation today to incorporate changes from new information just yesterday. Throughout the presentation, you'll see a bunch of websites to go to. We encourage you to do that. We have DOL websites with frequently asked questions, and we have a website from our law firm. You'll see it when the slide comes up, and it's all about COVID-19. And if you click on it, you'll see an absolute ton of resources. And to underscore that things change minute by minute, the House of Representatives just passed the CARES Act, which they were scheduled to do today, but that's now become the newest law, and that's probably about 5 or 10 minutes old. So Norma and I are going to go through some of the nuts and bolts of these new laws, and we have a bunch of the people, whoever sent in questions beforehand. Norma and I spent hours yesterday going through them and crafting answers, and we're going to give those answers to you. We all have other lists of questions as well, and we're going to try and give you the best advice that we can. Before we actually get to the presentation, the only other thing I want to say, and I've been saying this to all clients, I think the answers to your questions are part legal, part human resources, part public relations with your employees, and part common sense. I think that'll come through in the presentation today, because some of the information we'll give you is certainly legal, but a lot of it will fall into the other categories. So, all right, so if we could get move past this introduction slide. All right, so the first thing is don't panic. There's a lot of information. We need to build awareness and educate you and your employees on this. There's lots of things you can do to address what's going on, but most importantly, we want you guys to be prepared with as much information as we can. Yeah, you can move the slides. Not going to really spend any time on this. This is just this stuff is happening in real time. These are other infectious disease that we've had over the years, but this one is different. Next slide. Norma, why don't you just start with the new sick leave?
So the new sick leave law is part of the Families First Coronavirus Act. It actually provides for 2 types of law. We'll talk about that in a minute. Clarification we received this week is it is actually effective April 1, 2020, and I believe previously we thought it was going to be effective April 2nd, but the Department of Labor has issued guidance indicating it's effective on the 1st of April, and it runs through the end of the year. And it applies to employers with fewer than 500 employees.
Yeah,
David, I'll take this one. Yeah. Okay. So it provides for 2 types of leave. The first type of leave is paid sick leave, and the paid sick leave portion can be taken for one of the 6 reasons on the slide. We also received clarification or guidance on whether or not this leave can be taken intermittently, either this leave or the family leave. And the answer to the question is the first 4, if the leave is taken for one of the first 4 reasons, it cannot be taken intermittently. And the reason for that is they want these folks to stay home. It's also the reason that leave, not the intermittent part, but if you look at reasons 1 through 3, reasons 1 through 3 deal with the employees on sickness. And that's going to be the rationale for why they receive a higher rate of pay than for the other types of leave. So just to reiterate, we've gotten a lot of questions about whether this type of leave can be used for telecommuting, for intermittently, and the answer is yes. If you have your employees in the workplace, you may allow them to use intermittent leave, but only if it's not for one of the first 4 reasons.
And Norma, let me also add that for the first reason, the one question that we got, like you can imagine, it's pushing about 20 states that have stay-at-home orders, or there are some cities like Houston that have it, some counties like Orange County and things like that, but we don't have to worry about that in Illinois since we have a state one. Does that qualify for reason number 1 if you're subject to a state quarantine or isolation order? The answer to that is no. So it's not like just because you are exempt under that or subject to that, not exempt, does that mean this that all of your employees are now eligible for this because of Governor Pritzker's stay-at-home order? There was some back and forth of whether this was yes or no, but we got additional guidance within the last day or so that the answer to that is a big no. So, they're not qualified. Your workforce is not qualified for the sick leave just because of Governor Pritzker's order. Go ahead, Norma.
And to add to that, what reason number 1 is actually talking about is if a public health official has said, you must stay home and isolate, or you must stay home and quarantine. So it's an actual order or directive by a public health official, usually, that's going to qualify a person for this type of leave. And then the second type of leave is a doctor telling the employee to self-quarantine.
Should we go to the next slide?
Sure.
Okay. Keep going, Norma.
So I touched on this before. There are different levels of pay. If it's due to an illness or suspected illness of the employee, then they are going to get the higher rate of pay. So reasons 1 through 3, they get $511 per day, or up to $511 per day. So they're not going to get more than they would normally make. So there's a cap, and then the aggregate is $51.10. And then if it's reasons 4 through 6, they'll receive $200 per day maximum, or an aggregate cap of $2,000.
And if someone is working part-time, they get what they would normally, the number of hours they would normally get.
The last bullet point is a little bit important. We've gotten questions about this as well. It's the employee's election as to whether they use this leave first or any other type of accrued leave first. You can go to the next slide, please.
And before we do that, one question we're getting, obviously April 1st hasn't happened yet. So if you have had your people off before now, one question we get is, well, if we've given them some of the emergency paid sick leave time now, do we have to give it to them again? And the answer is yes, because it hasn't become law yet, effective. So anything that's happened before April 1st really doesn't count. Hopefully, I know I have some clients who've just paid their employees. I have some who have used PTO or sick time or something like that. But that law does not kick in until April 1st. So go ahead, Norma.
So the Department of Labor has now published the notice, and the notice can be found at the website as shown on the slide. You can download that, and what the guidance is that you should email that out to your employees or post it on your company intranet if you have it available. If you are still operating, then you would post this notice in the same place that you would post other employment notices. And then the tax credit, that is going to be applied to your payroll taxes, and just like you have to give employees sick leave starting on April 1, even if you've already given it to them, the tax credit will not apply to any sick leave that you've given to them prior to April 1.
Yeah, and the way the tax credit is going to work, according to what we understand, is if you've paid $3,000 in sick leave benefits, and you've paid $5,000 in payroll taxes for this employee for let's say the quarter, since you pay payroll taxes quarterly, instead of paying the $5,000 of payroll tax, you would deduct $3,000 for this credit, and then you would just pay $2,000. So there are no forms for it or anything like that yet. I assume stuff will all come, but that's the way they are anticipating this will work. Okay.
According to just one comment, Treasury is going to issue regulations and guidance next week, so we ought to be getting information on the tax credits next week. In terms of the expanded FMLA, I've seen a lot of questions about whether this is an additional 12 weeks of leave. So, for example, if an employee has already taken 6 weeks of FMLA, does that mean that the employee would be eligible for an additional 12 weeks of leave? And the answer is no. They're entitled to the leave, the 6 weeks that they haven't taken yet. And this leave, the expanded FMLA, is only available for an employee who is unable to work or telework in order to care for a child whose school or daycare is closed. So it's not the other reason.
Hang on a second, Norma. Let me just expand on that for a second. So if you go back, because this is really important and people are misunderstanding this. So if you look at the emergency sick leave, there's 6 reasons. One of the FMLA is only one reason. One of those reasons is one of the 6, but the FMLA is only for one reason, taking care of your children. Okay? So just to finish up this slide, it's any available, you know that regular FMLA, someone has to be employed for a year or work 1,250 hours. Here it's only 30 or more days. And the first 10 days of the expanded FMLA is unpaid, although they can use other paid leave time for those 10 days. And it's the same employee job restoration rights as, you know, the regular FMLA. And in general, I mean, Norma and I have had a lot of conversations about this. It seems like other normal FMLA rules and regs, you know, apply when in doubt.
And so, for example, this can be taken intermittently if the employer and the employee agree. And the DOL is actually encouraging employers to do that, but obviously you don't have to. David, do you want to take this one?
Sure. So also you can get, again, we're talking about the expanded FMLA. So we just mentioned the first 10 days are unpaid, but we would anticipate if someone is taking care of their children under the new sick leave, they would get paid there. And then that would be the first 2 weeks of expanded FMLA. So that would be paid. And then the additional 10 weeks, you also get paid at 2/3 of the regular rate of pay, up to a maximum of $200 a day, or $10,000 in the aggregate, plus the new sick leave. That aggregate is $12,000. And actually, if you look at the poster, it kind of spells that out as best as they can. And it's not a second, as Norma just said, it's not a second bite at FMLA. It is just 112 weeks. If someone had a baby in 2019 and that's within your benefits year for FMLA and they used it all up, they're not going to be eligible. There is an exemption if you have fewer than 50 employees. There is an exemption, and you know, unfortunately, we don't have forms or anything like that, or a ton of guidance on that. But you can apply for that. But I guess you would do that to the Department of Labor, and we don't really know what they're going to do with that. And again, there's another website at the bottom, and that takes you to a specific part of the firm's website with some information regarding this. Let's keep going. This is just more fact sheets where you can go. We have the Department of Labor information fact sheets and things like that. The poster. So please look at that. Okay, next slide.
David, let me make one comment on that.
Sure.
The Department of Labor is continually updating their questions and answers. And so, for example, 2 days ago was when they first posted the Q&As, and they've added about 15 more questions. And so don't forget to go back and visit that website daily, because they are updating that as they get more questions.
Okay. Again, the effective date of all of these laws is April 1st. Is it retroactive? No. And like we said, if anything was given prior to April 1st, no tax credit. It doesn't count. They still get the other benefits. And we already addressed this. Does the expanded FMLA create a new 12-week entitlement? No, just an additional reason. If they've used it up, they've used it up until the new year comes around for them for FMLA. And just so to mention, I think now Norma and I are going to transition to mainly answering questions that we have. What we've done so far is give you the nuts and bolts of what these laws are. And we'll also give you, as we answer the question, we'll give you more insight and guidance from what we've learned from reading all of these materials, as well as from our colleagues and other sources. So next slide. Go ahead, Norma, take this one.
So we actually already kind of answered this. If the work site closes, then prior to April 1, the employee is not entitled to sick leave. That same answer is going to be true for a variety of circumstances. If the work site closes and employees are not able to work, then they should be eligible for unemployment insurance. Next slide.
Okay, this is related. Keep going.
Oh, okay. So,
yeah, this one. Yeah.
Yeah, so essentially, at the point in time where the work site closes, the employee is no longer going to be able to take advantage of paid sick leave or expanded FMLA. At that point, unemployment insurance kicks in. And the reason that's so is because this federal legislation created these various packages to take care of employees. And so it's going to be paid out of one bucket if you're still operating. It's going to be paid out of a different bucket if you're not still operating.
And Norma kind of already talked about this, the intermittent leave. Can you? Yes, to a certain extent. Norma, anything else you want to expound on this one?
You know, I think what I've been reading in the guidance really is just that, especially for the workers who are teleworking and their schools are closed, the hope from the Department of Labor and all of the guidance that I'm seeing is that employers will allow those employees to teach their kids or help their kids while the kids are in school and work during off hours to make up the time. So that's what the guidance is. They're not going to mandate DOL. It seems to me that the employer and the employee have to agree that to the alternate work schedule or intermittent leave.
And, you know, we're getting a lot of questions about what sort of documentation. Well, you know, as you can imagine, this is moving so fast that the Department of Labor haven't exactly put out forms, you know, for this, but you should get certain information about this, the employee's name, the reason they want the leave, a statement that the employee is unable to work and why, which of the 6 reasons you're going to want this for the tax credit. And Norma and I, when we were talking, she came up with the really good practical solution. Come up with your own form, paid sick, COVID-19 paid sick leave, and just like, reasons, put down the 6 reasons with a check the box, that sort of thing, whatever, try and get some documentation, kind of good luck for that. Doctors are a little busy at the moment. So, do the best you can with that. For the paid sick leave, same thing for the expanded sick leave. I would get, expanded FMLA. I would get proof that the school has closed. I'm sure that if you just email them, or I'm sure there's something on their website, but do what you can, do what makes sense, because my guess is people are going to get audited for the tax credit, or even if they're not, you're going to want to have those records just in case. Next slide.
Just one more thing, David, on the website that we told you about for where you can find the frequently asked questions, question 15 and 16 expand on the documentation that employers should keep, and that's in the Families First Coronavirus Response Act questions and answers on the Department of Labor's website, and it gives you a couple pages of things that you should keep, and the things on this slide that you're looking at, these come directly from that question, but there's a lot more detail that would be helpful to you probably.
Norma, this is Cindy, and one of the questions that we got on a routine basis was for the child care provision. Are employers required to get documentation that the child care that's not available now was indeed compensated child care?
Yes. If you're going to, and in fact, one type of leave requires the child care to be compensated and the other appears not to. But if one of the requirements is that it be compensated child care, then the employee needs to provide you proof that they were paying for the child care. And that can be, I would think, a check made out to the child care provider, a check made out to the daycare, some type of proof. I think the Department of Labor or Treasury, if that's who were to audit you when you apply for your tax credits, I think there's going to be some flexibility given to employers on the types of documentation. For example, employees may not be able to get a note from the doctor saying that they're recommended to stay home. So instead, get the name of the doctor who made the recommendation, the date it was made, that type of thing. Get as much information as you can. I think that's going to be true with respect to proving that the child care provider was paid. Now, that may put the employee in a bit of a jam because some people are not paying taxes, payroll taxes to their daycare. You know, if it's an in-home provider, that's kind of a different issue. But as an employer, yes, you should require proof that the daycare provider or provider is being paid.
And again, this comes to a lot of common sense aspect of it, that do the best you can with it because the guidance only takes you so far, but use common sense. Get the best documentation that you can.
As a follow-up to that question, a lot of companies have parents of the same children working for them. So does the 12 weeks cover the parents as one parental unit? Does each parent get 12 weeks? Do you have any clarification on that?
Norma, I don't recall seeing clarification on that. Would the regular FMLA rules apply then?
I would think the regular FMLA rules apply, but which means that they would get a cap of 12 unless your policy says otherwise. But I have not seen any guidance to that effect.
We've seen that question more than once, and the only the best answer we have is that we think that the old rules will apply. You know, that as Norma just said. So that at this point, that's the best we can do with that. And again, unless your rules say something different.
And David, this is probably a good time to mention that Department of Labor has announced that there's going to be a 30-day period where they're trying to help employers implement these laws as opposed to penalizing employers for failing to implement them properly. And so I think that there's going to be this 30-day period where we all figure it out. And in the meantime, as long as employers are not willfully disobeying or they're doing the best they can, then from what I've seen in the guidance, the DOL is going to look the other way. Do you agree with that, David?
Yeah, I do. I think it comes from the fact that the DOL is working much faster than they normally do, because like laws and rules like this take months and months and months to get on the books with comments and things, and they're pushing this out, you know, in a very good fashion. And it's just, you know, when you have lawyers like Norma and I going through it, we pick up on things, and I think that their catch-all fallback is, hey, 30 days to figure this out. Don't worry, do the best you can. As long as you're acting in good faith, don't worry about it. So, yeah, I do. All right, we were going to move on to Cindy, unless you wanted to ask some of the questions at this point. You know, we were just going to move on and continue to do what we're doing.
I do have one more question, and this seems to be coming up quite a bit. Can an employee, if they qualify for one of more of the conditions that this applies to, how does that play out? Can they double dip, so to speak?
No.
Can
they get everything.
At all?
They get it. They're going to get everything once.
Okay. All right. Okay. I have one last question about the childcare provision. Do you have to be a parent or guardian to qualify for this?
Yes.
Okay.
Yeah, we got another question in another forum where someone asked if it could be a grandparent, and the answer is no.
Okay. Yeah, even if the parents are part of an essential business and need to work.
Right.
The idea, yes, the idea behind this is to provide income replacement for people who aren't able to work. And so if the employee is able to work, then this law doesn't apply to them.
Got it.
Right. If grandma and grandpa are just retired and staying home, there's no reason to pay them.
Okay.
All right. Anything else, Cindy, before we move on? Happy to answer more questions.
Why don't you continue? And we have a lot of questions coming in via email. Let me trend what's the most popular, and we'll go from there, but you can continue at this point.
Okay, so moving on to the Illinois stay-at-home order, you know, it's effective March 21st. It's supposed to go through April 7th. It'll probably get extended. We all know that. And you probably are all aware, requires individuals in the state to stay at home, non-essential businesses and operations to cease, prohibits travel unless it's to maintain an essential business, minimum basic activity or essential activities. We have the site for the order. We know you see it on the news all the time. You're supposed to stay at home unless you're going to go get food or go to the doctor, care for somebody else. You know, that sort of thing. Next slide, please. Okay, so getting right to it, many of the manufacturing companies are considered essential. You know, pharmaceutical, technology, biotech, healthcare, that whole list here. These are essential business operations, and they're exempted. They're permitted to stay open. Think about like the businesses who are closing or have closed. Think of your mall. You know, businesses in the mall are not essential, but manufacturing and supply chain operations are. Next slide, please. And you know, here's things that can remain open. Essential infrastructure. It makes sense. Food, distribution, sale, construction. Essential government functions. Obviously, first responders, etc. Governmental operations. Essential businesses and operations, stores that sell groceries, medicine, food, and beverage, things like that. But it's also the supply chain. One example I've used over and over is, and stay on this slide, please. No, go one more and stay there. Thank you. And for example, let's suppose you have a client, and we do, who makes paint for the auto industry. That is essential because they are part of the auto industry, is part of transportation, and paint is necessary for the cars, just as all the suppliers of parts are. So if you supply, you know, oil, or if you supply, you make robotics that make the things in this, or supply chain, or anything that happens to do. I have a client that makes industrial compressors and refrigeration units, and those are used in food and in pharmaceuticals. So anything that contributes to it is going to be essential. So we've had many clients call to say, are we essential? We ask what they do, we look at their website, and then we look at all of these sorts of things, and we say yes or no. And a lot of them have been surprised that they're yes, because they're not as familiar with these sorts of things. So the slide we're on now talks about, very importantly, there's a footnote 1 in Governor Pritzker's executive order, which refers to that first website where it says cisa.gov. The federal government has come through with a memo on what they have decided are the essential critical infrastructure. Could you go to the next slide? And here they are. 16 critical sectors that need to remain functioning according to the federal government, and Governor Pritzker has put these in. And part of the analysis is like, where do you fit? And if you go to that website, you can expand on those functions and see how you fit, depending on how you fit in one of these 16 critical areas, and see if you are in those areas. And if you are, you're able to remain, you know, open. You can keep going. Next slide. But before I address that slide, one of the questions we get a lot is, okay, so we're essential, we get to stay open, but we have people who are afraid. You know, what should you do? Practical common sense advice. If people can work from home, have them work from home. A lot of people can do their job at home. People who can't, if they have to come in, social distancing. Okay, and this is where I'll make the comment that I think more communication is better. I think it shows leadership. I think it shows confidence. If you tell people what you're doing, anyone who can work from home is working from home. If you have to work, we're going to comply with CDC social distancing regulations. People are 6 feet apart. We are regularly sanitizing the workplace. And the machines that you're working on, hand sanitizer is available. If you can wear gloves, things like that. Telling people that'll make them feel more comfortable. At the end of the day, if someone says they don't want to come to work because they're afraid, look, you can do what you want to do. You know, our advice has generally been that we're not going to force someone to come to work. And if they don't want to come to work when work is available, what happens? They can use PTO, they can go on unpaid leave. I don't know, Norma, do you disagree with any of that, or do you have any other thoughts?
I guess the only other thing I would say is if at the end of the day, you're concerned that let's say you deemed yourself to be an essential business and you're operating, and an employee says, I don't want to come to work because I'm afraid. I think that employers may have the concern that if you let that employee stay home, then that employee will tell other employees that you let them stay home and you let them take PTO. So if you're in one of those essential businesses and you're having trouble getting people to come to work, then that would be a circumstance where you could let them go off on leave, or frankly, you could treat them under your attendance policy. And if they are not working through their own choice, and fear is a choice, unfortunately, they would not then be eligible for unemployment probably, because they would be considered to have voluntarily left work. And that's a question that I saw a lot from members.
And I think that again, in terms of communications, that if someone doesn't want to come to work, when you tell them all the things you've done, and if they're still afraid, okay, well, this is what's likely going to happen. Go ahead, Cindy.
All of those. Yep. As a follow-up to this particular topic in terms of managing the workforce, if you're an essential business, we have had the request and question from many of our members that are asking about how do they treat their most vulnerable employees that are falling into the high-risk categories to catch the virus. What proactive steps can they take with their employees that they're not putting the high-risk employees in a position of jeopardy?
Norma, why don't you handle this one?
So all of the discrimination laws apply. So in other words, if you can't assume that because someone's 60 years old, or because someone may have some pre-existing medical condition, that they are not able to work. If the employee comes to you and says, I do not want to work because I have a compromised immune system or whatever it is, then you can consider that request and you can make an accommodation based on that request. But just as you wouldn't make a decision based on a stereotype in another situation, you shouldn't do so here. And in fact, the EEOC has put out guidance to that effect.
Okay, thank you. Okay. Yeah, because that question a lot.
Okay, Cindy, anything else?
This one should be an easy one to answer, and if you did cover it before, my apologies. We did have quite a few questions about, do the new rules apply to companies with less than even 50 employees? Are these for all employers of any size?
The answer is yes, under 500 employees, except that organizations 50 or less can apply for a hardship exemption.
Okay, all right. I have a couple other questions if it's time to interject that right now.
Go ahead.
With unemployment claims that companies are getting from their employees, should companies be responding to them, or is the general assumption that unemployment claims are because of the COVID-19 virus? What should the companies be doing? Because I'm sure they're being inundated.
Well, Norma, why don't you start with that, and if I have something, I'll add.
The employer, what I would do is do what you normally do. And so if you know that it's for, and in fact, if it's for a COVID-related reason, it's going to actually help your employee. If you say the employee is off work because he or she is subject to a quarantine order, or the employee is subject to, a recommendation from the doctor to stay home, that's also going to help you with your documentation in showing that, or perhaps, and this assumes that their 2-week period of leave has been exhausted and they still can't come back to work. So remember, you've got your 2 weeks of paid leave. But the usual rules should apply. If somebody quits because they don't want to come to work because they're afraid, then you can contest that if you choose.
Okay. And here's a question that I don't know if other companies have had to deal with, but it has popped up more than once. What if you've had a new hire that was supposed to start during this time frame, and maybe the company is not an essential business and they're closed, or it's an essential business and they're working with just the required staff. What's your suggestion for a new hire during this time? Do you put them on the books? Do you postpone hiring? What's your best suggestion on that?
Well, I guess I would handle that. I mean, it depends on the type of job, what they're doing. I would probably postpone, only because everything is so weird at the moment. We don't know who's working, who's not working, how long they'll be working. Now, I'll give you an example. April 1st, we're supposed to bring on a new lawyer in our group. And as the head of the group, I've been thinking, like, how do I do that? How do I integrate that person, properly when our office is closed? Or even if it wasn't, I mean, it's just not the same thing. But I think it's on a case-by-case basis. But to me, I'm not sure that it makes the most sense unless it's somebody that's critical. Norma,
so let me
anything?
jump in, because I actually advised on this one yesterday. It was a little bit of a different twist. The employee lives in a different state, not one of our neighbor states, but Maryland, for example. And the employee was supposed to start on April 5th, I think April 2nd or 3rd. And the employee has asked to telecommute. And the employer said no, because for one reason, if you have an employee working in a different state, there's the possibility that you might then become subject to paying taxes and registering to do business and all of those considerations. And so that person will have a delayed start date. I think that just gives you an example that it's a facts and circumstance test. And if you need the person, there's no reason that you can't bring them on, as long as you can go ahead and get them integrated into your workforce. But on the other hand, if you want to delay, then I think that's okay too. You should look at your offer letter and make sure that you haven't made some promise that you can't get out of, but short of that would be the only legal concern that I would have.
Yeah, I would agree with that. Cindy, others?
Yeah, one that keeps coming up a lot is that when this comes into play effective April 1st, and the first 80 hours are covered under this emergency sick leave, is that 80 hours, consecutive 80 hours? What about for companies that have taken their full-time 40-hour per week employees and have now reduced them to 20 hours a week? How does that play out?
Well, first of all, you have to fall on, it's not an automatic 80 hours. You have to fall into one of the 6 categories. And Norma, I don't know that I recall. Can you get that? Is it under the 80 hours? My recollection is it's all or nothing. It's not like half and half.
Well, the new guidance says that that they can take it intermittently, as long as it's not for their own sickness. So that would be the child care part.
Right.
I think maybe there's a different question there. Is the question if they have been reduced to part-time because of COVID-19, do they get paid at 40 hours a week or 20 hours a week? And my thought, and I haven't seen any guidance on this, but my thought would be that if the reduction in hours occurred before April 1, then the replacement pay that they get, if they fit in one of the categories, would be at the reduced hours rate, because then they're a part-time employee. And then if they qualify for unemployment under the reduced hours exception, then perhaps they could get unemployment, partial unemployment. But I haven't seen any guidance. That would just be my analysis. Well. David, thoughts?
No, I think that's right, and there are so many permutations on this, and again, it depends company to company, but there's so many permutations on this. When we get these sorts of questions, we kind of look at each other and say, okay, no guidance on this. What do the normal, regular laws say? And that's just one of, the questions. I mean, that makes sense. I mean, the employees could actually be penalized financially by being put on reduced hours in terms of the 80 hours and unemployment than if they were paid, full time. But I guess unfortunately, it is what it is.
But I actually think I think that may be dealt with in the CARES Act on the unemployment side. But the other thing I want to mention is, the reduction in hours and reducing people to part-time. I assume that that's non-exempt employees, because if you're changing the hours of work for an exempt employee and reducing their pay by the hours reduction, that can get you into a little bit of trouble under a different law. So I don't know the context of that question, Cindy.
Yeah, but your interpretation has been what we have come to understand as well, is that if there is a reduction in hours for the non-exempt employees, it would be considered under unemployment insurance for the difference.
Yeah.
One question that we've been getting, and maybe you've had experience with this week, is how are these laws going to be implemented in the constructs of a collective bargaining agreement?
Well, what you're going to have to do is you got to go to your agreement. Now, they're still going to be entitled to, these are laws. Just because you have a collective bargaining agreement doesn't mean you don't follow the laws. But where the collective bargaining agreement is going to come into play is what are the provisions of the collective bargaining agreement as to sick time, PTO, and when you can use it, rules and regulations that way. So, and if the employer is going to make changes to this, like furloughing people, to what rights do they have? How are they going to choose people? You're going to go based on the seniority provisions in the collective bargaining agreement. You're going to look at who has skill, who has seniority. So in terms of reduction in hours, does the management rights clause permit that? A proper one would, but some of these things may even have to be negotiated with the union. So it's just, whereas everything Norma and I have been talking about assumes no collective bargaining agreement, where employers can just make the decision that they believe is best. When you have a collective bargaining agreement, you have to follow the rules in the agreement, or you're going to have to negotiate over things. And in fact, I read that there was in Kentucky, I think there was a strike at one of the food warehouses because of the way the employer was handling something related to COVID-19. So, it's a different environment.
And now on the flip side of that, if a company has a lot of temporary employees, how is that handled? Is it the temporary agency that's responsible for implementing these acts, or is it the actual employer where they're going to every day?
Norma, why don't you start with this one? Norma, you there?
I actually had a little bit of technical difficulty for a moment, David. Could you either
I'll
repeat the question or you take it? Sorry about that.
That's okay. That's all right. So, it's, again, when you have, an employee or an individual that you get from a temp agency, the question is, who controls that? And it's usually kind of both. But as the employer, I'll assume that it's the employer who has whose premises they come to every day. You're going to have to make the decision who works, who doesn't work. In terms of paying them, I suspect that they'll still be eligible. Since you're the one paying them, I would assume that the employer where they're working would have to pay them. Or I actually haven't seen guidance on, because they would get tax credits no matter who pays them. So I don't really know who would be paying them. Cindy, tell me the question one more time. I want to make sure that I didn't miss any of it.
Oh, hold on. Hold on. Go ahead, move on while I find it, because about 10 others have just come in. Go ahead, we'll revisit that.
Can we go to the next slide? It just lists all the state's orders, and it doesn't really matter because we're just in Illinois. Can I ban travel? More questions, and these questions come from all sorts of places. Can I ban employee travel to affected locations? Yes. You can ban any business-related travel. We generally don't ask about lawful off-duty work, but if they go to places they're not supposed to, that you can quarantine them for 14 days. And do that. Can I force a sick employee to go home or stay home? Yes, likely yes. If they have obvious symptoms, if they have a cold, if they're coughing, if they're sneezing, or if they are achy, send them home. I mean, we're not going to take chances here. Then what do you do with them when they go home? You got to monitor us. Say like, did you get tested? Did you have the flu? Did you get a COVID test? What sort of thing is that? You may, on the safe side, I would recommend keep them home for the 14 days. And the guidance is that, and then 72 hours after no flu-like symptoms, without medicine, just, keep them home.
David, can I jump in here real quick?
Yeah.
David? Okay, so
yeah.
I just want to remind everybody, we have different rules in place right now because of what's going on. And so for those of you who are on the phone and aren't usually handling HR issues, this isn't the normal way that we do business. Normally, the employer under the Americans with Disabilities Act can't ask a lot of these questions. Because of the pandemic, because of the threat, the EEOC has come out with guidance that says you can ask these questions. So just understand that this is a special circumstance, and normally you're not going to be asking a lot of these things. You're not going to be taking temperatures. Those kinds of things are not allowed, but for now they are. I just wanted to say that so that everybody's clear that when we get back to normal, we have to go back to following the normal rules.
And, let me follow up on taking temperatures. Like Norma said, you can do that. I mean, I don't know that that's something that's helpful from the reading that I've done on that specific point. Is we all know that 98.6 is a, quote, normal temperature, but every human has a slightly different normal temperature. So when is someone sick? Is it 99, 99.5? Your temperature, I understand, can vary, during different times of the day. So, I'm not sure what good that does. So let's go on to the next question.
And I did find the one about employees.
I'm sorry, go ahead. Say that again, Cindy.
Yep, I found the one on temporary employees, and I will read this to you word for word and let you decipher from there. To apply for the waiver because of 50 employees or less, but we have over 20 temp employees at any given time, does the waiver still apply to us?
Because they're, my gut wants, I don't, do you have an answer for that one, Norma?
I don't, but why don't we skip it for now, because I haven't seen guidance, but I'm going to flip into the questions and answers while we're moving through these slides, because there is a question about how you count. I just want to look at it, but let's keep going through the questions, and if I get an answer, I'll pop back in and tell you.
Okay, so
about minutes left on the call. In terms of the questions that we've received, a lot of those that we've been able to put under a general theme have been answered. Most of them that I'm getting are much, much more specific. If you want to find that one on how to count, Norma, that would be great. David, if you want to continue with the slides for the moment, that would be a good way to move forward.
Agreed. We're going to divide and conquer. I'll keep going with the slides, and Norma will do research. Go back to the prior slide. So what should I tell employees if we have a confirmed coronavirus case? So this is where communications and common sense plus the law factor in. So you can't say who has the who tested positive. There's privacy issues. There's ADA and EEOC guidelines that would prohibit you from identifying that person. However, I think that the employees have a right to know, but I think that then part of that communication should be, what have you done in response to that, in terms of cleaning the workplace, in terms of separation, hand sanitizer, that sort of thing. Identify the steps that you've taken. So that's an opportunity to, I mean, look, some people may be afraid. They may ask, where did that person work? That sort of thing, and it may cause other issues. But I will also tell you, remember I mentioned that strike at a food warehouse, it was directly related to the employer not telling the employees that there was someone who tested positive. The employees were so upset they walked out. So, you know, you gotta balance that. All right, so the next slide. If we furlough or temporary layoff due to coronavirus, are they entitled to receive unemployment? Generally, yes. You know, and we think the answer would be yes in Illinois. May I require employees to use paid time off for self-quarantine or in the event that they're sent home to dinner? Yes. They may generally require it as so long as it's consistent with, and you got to look at your policies and the way you've done things in the past. And here's like a union comment. You got to look at the collective bargaining agreement. So in general, I would say yes, as long as it's consistent with what you do.
Can I jump in?
Yeah.
Oh, wait. So I found the answer to the question about counting temps. It is question number 2 in the Q&A that I referred to before. And it says that you should include employees on leave, temporary employees who are jointly employed by you and another employer, and then it goes on, it says, regardless of whether the jointly employed employees are maintained on only your or another employer's payroll, and day laborers supplied by a temporary agency, regardless of whether you are the temporary agency or the client firm, if there's a continuing employment relationship.
Fabulous. Great on-the-fly research. Now, my question to you, Norma, is who would be paying them the 80 hours? You know, where they're actually working, or the temp agency?
I think the person, whoever the payroll employer is, would be the one, because they would be getting the tax credit. And then, does that make sense?
Well, it would seem to me
so if
the temp agency, because they're the ones actually paying.
Correct. Okay. So back on the slide that we're talking about here, I just want to make sure that we point out that if someone has the paid sick leave available to them, they get to use the paid sick leave, the new paid sick leave first.
Good point. Right.
So
that in the line of, there's different buckets of pay. One is the new laws, another was PTO, things like that. The bucket that has to be used first, if they're eligible for it, is the new sick pay. All right, next slide.
And Dave and Norma, we still keep getting questions, even during the call today, that the new laws go into effect April 1st. So anything that's happened before that time, companies should be following their standard procedures. Correct?
Correct.
Okay, gotcha.
Okay. This is we've kind of addressed this one. Let's go to the next one.
Yeah, and we do final right now. We are at almost at the 2 o'clock hour, so we do need to wrap this up.
Last question. Are workers that contract COVID-19 eligible for workers' compensation? Only if they can show that it was contracted in the workplace. We believe that's going to be kind of hard to do. Obviously, a little bit easier if you had many cases in there. But again, it'd be best if you showed what the employer did to ameliorate, and take steps to prevent the spread of it. That would be your defense in workers' comp. So, Cindy, is that our last question?
That is our last question. And to those of you that are listening on the call, I know we did not get to everything, but based on what we have seen in questions since Monday and what has come in during this call today, I am hopeful that we have covered the general themes that so many of you have had questions about. I'd like to thank our presenters, David Ritter and Norma Zeitler from Barnes & Thornburg. I encourage all of you on the call to keep your questions coming to us at the IMA mailbox that we mentioned earlier, and that address is on the screen right now, ima@ima-net.org. What our team will be doing during the weekend is consolidating all of the questions that we're getting, whether it is related to the Families First Care Act whether it's related to the governor's executive order, and certainly as it's created to the CARE Act now that that's passed out of Congress. We have been putting together where the needs are in terms of the information our members need and responding to them as quickly as possible and getting our experts like those from Barnes and Thornburg to put together webinars like this. So we'll be doing our planning as the questions come in, so please keep them coming in and we will try to answer them ourselves if it's something routine that we have seen over and over again. I would also like to emphasize, if you are getting our daily email updates on COVID-19, please pay attention to them. We're keeping them as timely as possible. As we get more webinars scheduled on this topic, we will make sure you get that information as well. The next one that we do have on the docket is scheduled for March 31st, and it's the implications of COVID-19 as it applies to Osha. So if you're not the right person for that webinar, please get it to the safety professional in your company. For those of you that are not IMA members, you can also send us your email questions to the website that's shown on the page. We will get to you as well so that you're getting current and accurate information. And again, I'd like to thank Norma Zeitler and David Ritter from Barnes and Thornburg for their expertise today. And to those on the call, thank you for all the hard work you're doing this week. Good luck as we go into the future, and please pay attention to our content. We're trying to keep it as timely and relevant as possible. To the IMA team that's on this call, thank you for your help in pulling this off today. Thank you. Stay healthy, everyone.
Thank
This
you.
brings it all to an end.